Welcome. While we have been visiting the provisions of trial, we have noticed that in respect of the ingredients as well as in respect of the relevancy of facts, one particular concept which remains at the center is a mens rea, a mental state, and meeting of minds. And the conceptual term being used is an agreement. Now, agreement as such is a civil law term as well. So, this agreement, as is conceptualized in criminal law as an agreement between two persons, means regarding their agreement over a particular transaction, particular event, particular chain of steps, particular motive, particular common object, and all that. But as far as the civil law is concerned, there the agreements are permitted to be constituted in a particular specific manner. And when those agreements are having sanction of the law, which are enforceable by law, those become contracts. So we have to have appreciation of reaching at an agreement in the criminal law parlance and the agreement reach in civil law parlance, and then agreement as contract under Indian Contract Act. The difference between the degree of difference between agreement and contract is that when agreements are enforceable by law, those become contracts. Agreements which are not enforceable law remain simple agreements, but when agreements are enforceable by law, those become the contracts. The term used is normally memorandum of understanding. No, memorandum of understanding as well is an agreement. However, whether memorandum of understanding is contract, then we have to appreciate many other attending circumstances as well. Now, today we are visiting the provisions of Chapter 1 of the Indian Contract Act. This is the basic set of provisions which give a legislative sanction for the process to reach at an agreement. When law will presume that parties have reached at an agreement, it is that situation which is going to be visited by us. This Chapter 1 is a setup of Section 3 to Section 9 of the Indian Contract Act. The title of the chapter is Of the Communication, Acceptance and Revocation of Proposals. See, there is an communication is the first word, then acceptance and revocation are the two other words, and these all are with respect to the proposals. So, proposal is the basic term in reference to which there are communications, and those communications are of the standards of acceptance and revocation. Therefore, while we will appreciate the ingredients of these terms, then we have to note down that the word communication, word acceptance, word revocation, and word proposal are quadruple words, definitions, or concepts in reference to which everything is to be appreciated. Now, Section 3 communication, acceptance and revocation of proposals, then communication when complete. So communications is a general happening, but when that communication becomes complete is the specific situation which is recognized by the law. Legislative sanction is for a particular stage of the communications when these are taken to be complete. And revocation of proposals and acceptances of the concept. Then there is revocation, how it is to be made, how revocation of the proposal is to be revoked. There is a specific procedure, there are specific features of this concept. Then acceptance must be absolute. Here the word is an absolute, means if there is an acceptance, its basic feature is that it shall be complete. Means whatever the form of the proposal is, it is to be accepted absolutely, not with conditions, no restrictions, no alterations, no deviations. They not accept the proposal, but if it is to be accepted, it is to be absolute. And then acceptance by performing conditions or receiving consideration. It is one mode, which means if there is some proposal, then its acceptance can be by communication, or the acceptance can be performance of the conditions, or by receiving the consideration. So there are three different situations of the acceptance of the proposals. Number one, by specific communication. Number two, by performing the conditions. Number three, by receiving the consideration. And the 9 is promises expressed and implied. Now, the word promises are the mutual considerations. There are two persons, A and B. A proposes, means A promises to do something or not to do something, and in respect of it, the B, the other person, also gives some promises of acceptance or non-acceptance, and those promises in fact become the considerations of each other. So there could be considerations in the form of promises of both the parties. Now let us see what precisely these provisions are. Section 3, communication of proposals, the acceptance of proposals and revocation of proposals and acceptances respectively are deemed to be made by an act or omission of the party proposing, accepting, or revoking, by which he intends to communicate such proposal, acceptance, or revocation, which has the effect of communicating it. Now see, the communication in normal parlance would means A speaks something, means conveys something orally. It also can be in writing. Then these legislative provision here, the definition here, the law here in section 3 is not remaining only up till that it says by which he intends to communicate such proposal. Now, there is some hidden format. It may not be by specific word, say, I accept it. It may not be by acceptance by a written communication, writing, I accept it. It says that if we act, means any form of action or omission of, then if any act or omission intends to communicate. So normally the communication may be taken when A and B are in front of each other A communicates by mouth and B hears it by ears. Then it may not be by the explicit spoken words, it may be by nods of the heads, or there could be many other forms of gestures which are taken to be the communications here. So acts or omissions which intend to communicate as well is being taken as a communication. So see again, the communication of proposals, number one, acceptance of proposals, number two, revocation of proposal, number three. So there are three situations: to make a proposal, to accept a proposal, to revoke a proposal. So there are three situations with respect to which our communications are being considered. The communication, number one, of proposal, the acceptance of proposal, and the revocation proposal. And then the acceptances respectively are deemed to be made, So here is a legal presumption. Here is legislative sanction for deeming that same stands made by any act or omission of the party. So acts and omissions in this context are the features which deserve to be appreciated. It is to be imbibed as these have legislative sanction. There is a legislative seal. It is the law. Therefore, to appreciate that, we have to appreciate number one word, communication, second, proposal, third, acceptance of proposal, fourth, revocation of proposal, and then deemed to be made, and then act or omission. Therefore, these all terms ultimately in real litigation stages become very important, as by in determination of the same only the decisions are to be reached at. For communication when complete. Now see, this is very important. Communication of a proposal is complete. Now it's a definition. When it comes to the knowledge of the person to whom it is made. The word used is knowledge. For example, A sends say some communication in writing through a postcard, and that postcard reaches at the address given, and the person to whom it is addressed is not at that address at that place. However, somebody else is there, maybe some office clerk. And if the office clerk conveys it, then it becomes within the knowledge. So the communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. The word is, the test is, the touchstone is knowledge. A makes a communication if it reaches, which may be inferred as a knowledge of the person. B. So A communicates a proposal, and when it becomes within the knowledge domain, within the knowledge or of the knowledge of the person of B, then this communication of A means this communication will become complete. C. Section 3. Communications are to be made for what? Number one, proposals. Number two, acceptance of proposals. Number three, the revocation of proposals. All the three situations: to make a proposal, then to accept a proposal, to revoke a proposal. A can make a proposal, B can accept it, and A again can revoke it. So there are three sources of communication. Firstly, for proposal A, for acceptance B, for revocation A. Therefore, the communication is to be appreciated from the point of view of the source of the communication. For proposer, say A is the source. So A will be making a communication of a proposal to B. Now, this proposal of A for B will become complete only when this proposal has come within the knowledge of a B. Now, for example, A has made a proposal to B, say through letter or some another process. Medium of communication here as such is being not defined. There may be any medium. So A has made a communication of a proposal. And for example, before it reaches B, or before it comes to the knowledge of a B, A makes another communication of revocation. So A, as a source of communication of the proposal, has sent the communication. So communication is in the medium. It may have reached to the knowledge of B, or it may have not reached to the knowledge of B. And here A sends another communication of revocation of the earlier proposal communication. No, there will be situations. Therefore, this provision of section 4 is to be reread in this different spectrum of situations. The communication of a proposal is complete when it comes to the knowledge of the person to whom it is made. Then added, the communication of an acceptance is complete. Now, initial communication is with respect to a proposal. Now, it is here with respect to the acceptance of the proposal as against the proposer when it is put in a course of communication to him. See, A has sent a proposal. The communication reaches B. B accepts it and sends a communication of acceptance. Now, this communication of acceptance by B, when is put in course of transmission, it has not reached A, but B has put the communication of acceptance in a course of transmission. Still, it has not reached A, but it will become complete against A. The proposal of A, when is accepted, an acceptor B puts the communication of acceptance in course of, so it is still in the course of transmission and it has not reached A, but it is complete. That means the moment B has accepted and put the communication of acceptance in transmission for A, in transmission for A, it may or may not have reached. So the moment B puts the communication of acceptance in transmission for A, in transmission for A, it may or may not have reached A. It may be in between somewhere. But for A, the acceptance is complete. As against the acceptor, when it comes to the knowledge of the proposal. And now, if that communication of acceptance sent by B, the moment it is put in transmission, it is complete for A. And when the same reaches B, A, then it is complete for B as well. The communication of acceptance is to flow from B, from another end. Moment B accepts it and puts the communication in transmission, means puts in the process. The moment he puts in process, it is complete qua A. He can't revoke. It is qua A. However, when it reaches A, then it is complete qua B. Now B can't revoke it. Let us see again communication of an acceptance. The communication of proposal is simple. It is complete when it comes to the knowledge of other person. As far as the communication of acceptance is concerned, it has different features. The moment acceptor puts the communication in transmission, that very moment it becomes complete qua the proposal. And when it reaches the proposal, then it becomes complete qua the acceptor. So these two situations deserve to be appreciated by having a distinctive gap. The communication is to be through a medium. The medium will take a time. So there is a time gap between the moment of initiating communication and it reaching its object where it is to be sent. The time taken by the communication to reach, the time taken by the medium to complete transmission of the communication. So you have to appreciate it as a left hand and a right hand. Left hand says a proposal, right hand is an acceptor. A sends a proposal. He pushes. It is still in between. It has not reached B. So it is of no concern for B. Right hand has no vested interest in it. A has sent it. Left hand has pushed something, a ball. Ball has not reached the right hand. So right hand has no impact whatsoever. And the left hand can chase the ball, and before it reaches the right hand, can push it back, pull it back. So illustrate, there is a left hand which pushes a ball towards the right hand. Till the ball reaches right hand, means till it is within the knowledge of the right hand, means till ball comes in the right hand. So ball pushed by the left hand and it has not reached the right hand, then the left hand can, if possible, can take that ball back. And right hand cannot say why it is taken back. However, when the ball reaches a right hand and the right hand pushes it towards the left hand, the moment right hand pushes the ball, then it becomes complete K. Now A can't say, I withdraw it, because that ball which is coming, it is coming from B. The left hand can take back the ball till it has not reached right hand. But once it reaches right hand, then the left hand has no impact over it. If the right hand doesn't push it, it permits it to continue there, then there is no acceptance yet. The acceptance will be when the right hand will also push the ball. If right hand has not pushed the ball, then still it is within the proposal to withdraw the proposal. However, the moment right hand pushes the ball, once push is there for that ball, then left hand has got no right to say that it is the same ball or it is the ball of within his reach. Now, and moment this ball, which is pushed by right hand, reaches the left hand, then the right hand as well has no control over it. So the B, when gives an communication and gives a push to a ball and it has not reached left hand, then right hand can chase it and take it back. See again, A has a ball in his hand. This ball is put in communication. It doesn't reach the right hand. Till the ball is not reaching the right hand, then the left hand can take it back. And that particular stage, when it has reached B, but B has not pushed it back, has not given acceptance to it. So at that stage as well, left hand can snatch away from the right hand. We take it back. It says, I am taking it back. But the moment right hand has pushed it, means given an acceptance, put it in transmission course towards A, then A, his proposal is complete. However, if it has yet not reached A, then B can take it back. Therefore, take a paper, draw 2 points A and B, connect them by a line, and say one point or one ring or one ball is there. So between nail A and nail B, and if this ring is pushed, then see the different stages. Like that, when it is pushed back, see those things. Therefore, this provision of section 4 is at a next stage now. The communication of a revocation is complete. A has given a proposal to B. B has pushed it. It has yet not reached it. It was complete moment pushed towards A. Towards B, it will be complete when to see what its purpose says. As against the person who makes it, means who revokes it. Proposal can be revoked. When it is put in the course of transmission to the person to whom it is made, so as to be out of the power of the person who makes it, as against the person whom it is made, when it comes to his knowledge. Same as was with respect to the original proposal. Now, this revocation of is not only of proposal, the revocation could be of acceptance as well. Therefore, these illustrations given, A proposes by letter to sell a house to B at a certain price. The communication of proposal is complete and B receives the letter. Second illustration, B accepts A's proposal by a letter sent by post. Communication of the acceptance is complete as against A, and the letter is put as against B, and the letter is received by A. C, A revokes his proposal by telegram. Revocation is complete as against A when the telegram is dispatched. It is complete as against B when B receives it. B revokes his acceptance by telegram. B's revocation is complete against B when the telegram is dispatched, and as against A when it reaches him. These three illustrations be read again, the same be translated in a pictorial form, taking A nail at wall A, B at a nail at wall B, and there is a rope in between, and some rings are being sent from here and pushed back. Try to appreciate this legislative seal, this legislative method, this lawful methodology, this lawful format for having communications. Thank you very much.
Sir, I have seen this illustration. I have a small question. Let us say there are two ends, A and B.
True.
A sends proposal to B through a letter.
Yes, illustration A.
Yeah, and B receives it, and now communication between A and B is complete. The proposal has gone from A.
No, A and B is complete. Means it is complete qua A.
Yes, complete qua A. Now let us say during the time of transit between A to B, A wants to revoke it.
Before it
Now the
reaches
revocation.
B, before it reaches B.
No, obviously the first proposal will reach to B first.
And no,
So
no,
without reaching, without reaching B, A sends a proposal.
True.
Without reaching B, A sends the revocation. Now B receives the first proposal, and the revocation at a later stage. And before he receives the revocation, the B has sent the consent acceptance back to A. So what is the stage?
What you are putting is A has pushed a ball, it has yet not reached B, and then
in between.
Then A stretches a hand and picks up the ball.
Yeah.
If he has picked up the ball, means he has second proposal which he has revocation, say, which he has sent.
Yeah.
And this revocation is permissible to him if the time is fixed, if it is clear that before ball reached A, if A had sent a revocation, then it does not make a difference that previous proposal reaches first or the second revocation reaches first.
Yeah, which means the first proposal, if without revocation, the proposal is received by B, and B has sent the acceptance also. And then
it's again a timeline. You put time. At moment A, B has reached B. The ball has reached B. At point P2, the revocation has been sent. If P2 is a subsequent time, no implication. If P2 is prior to P1, then it's there. So you put it on a timeline.
I'm just trying. Let us say A sends a proposal to B on 1st of January. I'm just quoting an example, sir.
Good, very good.
Yeah, 1st of January, A makes a proposal, sends a proposal to B through letter.
True.
Right, and B has not yet received on 2nd January. Let me first complete, sir. The proposal has not yet reached B, and on 2nd of January, A again revokes it. So now
not again for the first time. Revoking for the first time.
Revoking for the first time. So now the proposal reaches B on 3rd. The first proposal, which was sent on 1st, it was received by B on 3rd.
True. And on 2nd, he has revoked it.
No, he has revoked it, but B has not received it.
May not. It is nowhere. It is not the effect. Provided this is what I'm saying. The law is making it complete. The communication will be complete when it comes to the knowledge of others.
Yeah. So my simple question is, sir, A has sent a proposal to B on 1st, and on 2nd, A has revoked it.
True.
Yeah. B received the first proposal on 3rd.
No, there's no effect of it. No effect.
No, sir. And he accepted it and sent it back to A.
Maybe.
And now the revocation he received on 4th.
Maybe.
So will that contract be that agreement will be legal or illegal?
You see, if we are going by a definition, then it clearly says A proposal, if he is not complete qua him, he can revoke it. The proposal of A sent on 1st is not complete as it has not reached up till 2nd. So up till 2nd, the proposal was not complete for A. It was not binding upon him. It was not complete. So he can revoke it. It doesn't make a difference. It does not make a difference if the first.
But B may say, sir, B may say that I have without revoking, I have received it, I have accepted it, and revocation was not in my knowledge.
He is nobody. The ball is of the left hand. Left hand had a ball. Right hand has no control, no right, no vested right, no interest whatsoever it is. Right hand, nothing to do with the ball. Ball and left hand are one. Once the ball is in the left hand and it is sent, it does not reach the right hand. The right hand has no claim over the ball at all. So if he catches before, it's all right.
No, sir, the first ball has reached. The first proposal has reached.
Reach subsequent to that. Reached subsequent to the revocation. Reached subsequent to the revocation. It has no effect.
Okay.
All right. Nice.
Right, sir. Thank you.
Thank you. Thank you.